On the night of March 19, 1906, in Chattanooga, Tennessee, a crowd gathered outside a jail that should have been secure. Inside was Ed Johnson, a 24-year-old black laborer, a man who, on paper at least, wasn't supposed to die that night, because something rare had happened. The United States Supreme Court had stepped in and issued a stay that should have stopped everything. But the stay didn't stop the crowd. It didn't stop the men arriving with tools. And it didn't stop what happened next, on a bridge that still stands today. What makes this case different from so many other acts of racial terror in that era isn't only the violence. It's what happened afterward. Because this wasn't just another injustice that faded into the background. It became the only time in American history that the U.S. Supreme Court would go on to effectively conduct a criminal trial set in motion by a lynching meant to mock the court's authority. So tonight, let's walk through this carefully, step by step, because the scariest part isn't the bridge. And before we get into it, if you appreciate calm, fact-based true crime stories told step by step, consider hitting on the subscribe button. It really helps the channel, and it means you won't miss the next case. The scariest part is how easily a system can bend when a community has already decided what it wants the outcome to be. Chattanooga in the early 1900s was balancing two versions of itself. On one hand, industry, growth, streetcars running through downtown. On the other, an American South still shaped by the end of Reconstruction, by laws designed to restrict black rights, and by the constant threat of racial violence used to enforce order. And here's what matters. Violence doesn't always start with a weapon. Sometimes it starts with a story repeated often enough, confidently enough, that it becomes truth before evidence even exists. In late 1905 and early 1906, white newspapers and public talk in Chattanooga stoked fear of a so-called black crime wave. And in that climate, an accusation, especially involving a white woman, could become a death sentence long before a courtroom heard a word. The two people at the center of this story were real human beings. Nevada Taylor was 21 years old. She worked in bookkeeping downtown and lived on the outskirts of Chattanooga near Forest Hill Cemetery, where her father worked as caretaker. And Ed Johnson, young, black, working class, would later say he was simply trying to live his life. Accounts summarize that Johnson said he was working at a local saloon the night of the attack, and multiple witnesses supported that. The key date is January 23, 1906. That evening, Nevada Taylor took a streetcar home and began the familiar walk toward her house. Sometime after 6:30 p.m., she was sexually assaulted. Later accounts describe how difficult identification was, because it was dark, and she didn't get a clear look at the attacker. Police found little. One detail that kept showing up in reports was a leather strap, something investigators believed may have been involved. But beyond that, the case began to shift. Not an investigation guided by evidence, but a search for a suspect who fit the expectations of the moment. Sheriff Joseph F. Shipp offered a reward for information, starting at $50 and rising as others added money, eventually reaching $375. Rewards can motivate honest tips, but they can also motivate something else. At first, investigators arrested another black man, James Broughton, who insisted he was innocent. Then a white witness, Will Hickson, claimed he saw a black man near the streetcar stop, twirling a leather strap around his finger, around the time of the assault. Later, Hickson identified that man as Ed Johnson. And all the while, that reward money hung in the air like a magnet. Johnson was arrested January 25, 1906, and almost immediately, things escalated. That night, a mob, reported in some accounts as over 1,500 armed people, gathered outside the jail demanding Johnson be turned over. Officials moved Johnson out of town to Nashville for safety. That alone tells you something. Authorities understood exactly what was possible here, even as the legal process moved forward in a way that did very little to protect a fair outcome. On January 27, 1906, Nevada Taylor traveled to Nashville to identify her attacker. And this is one of the strangest parts of the case. According to historical summaries, Johnson and Brodin were positioned so Taylor could hear them speak. Essentially a voice identification. Taylor said Johnson had the same soft, kind voice she remembered. But even later, sources note she could not swear with certainty that it was him. Soon after, Johnson was indicted, and the trial was set fast. The trial began February 6, 1906, just 10 days after the indictment. Johnson couldn't afford a lawyer. The court appointed attorneys for him, white attorneys with limited time to prepare. And Johnson was being held away from Chattanooga, making it even harder to build a defense. Inside the courtroom, the atmosphere mattered as much as the testimony. Historical accounts describe spectators heckling the defense, even witnesses, and the judge not stepping in to control it. The state's case leaned heavily on circumstantial points. The darkness, the uncertainty, the strap detail, Hickson's claim, and the voice identification. The defense pushed back, pointing to weaknesses, questioning the reliability of identifying someone at night, and the influence of reward money. And then there was Johnson's alibi. Johnson said he was working at a local saloon, often described as the Last Chance Saloon, and multiple witnesses supported that claim. After about 6 hours of deliberation, the all-white jury was split 8-4, with 4 favoring innocence. That's not a small detail. That's doubt. Real doubt, inside a courtroom under pressure. The judge dismissed them for the evening, and overnight, the jurors' names were published in the newspaper, exposing them to pressure, retaliation, and fear. When they returned, they quickly reached a guilty verdict. Ed Johnson was sentenced to death, set for March 13, 1906. After the verdict, even Johnson's original defense team reportedly hesitated about appeals, because in that climate, a legal win could provoke a lynch mob anyway. But Johnson's father kept pushing, and this is where 2 names enter the story. 2 men who understood exactly what they were risking. Noah Pardon and Styles L. Hutchins, black attorneys in Chattanooga, took up Johnson's case and fought for appeals when others wouldn't. They tried through the Tennessee courts. When that failed, they went federal, seeking habeas relief, arguing the trial violated constitutional due process. For that time, it was a bold move. Then comes Justice John Marshall Harlan, the same Supreme Court justice known as the lone dissenter in Plessy v. Ferguson. Harlan reviewed the case and issued a stay around March 18 to 19, 1906, moving to bring the case before the court. Chattanooga officials, including Sheriff Shipp, were informed. Legally, that should have meant a pause, but socially, it did the opposite. To many white residents, the Supreme Court's involvement felt like humiliation, like outside interference, like a delay they didn't want. And then, the night came. On the evening of March 19, 1906, a mob gathered at the Hamilton County Jail. Despite the risk, despite earlier mob pressure, deputies were sent home, leaving minimal protection. The mob broke in, and they took Ed Johnson. They marched him through the city to the Walnut Street Bridge, over the Tennessee River, a place that today looks ordinary, almost peaceful. On the bridge, the mob demanded a confession, but Johnson didn't give them what they wanted. Multiple historical accounts preserve some version of his final words. "God bless you all. I am innocent." What happened next was murder carried out in public. Meant to be seen, meant to be remembered, meant to terrorize. Records indicate shots were fired as well. I won't go further than that. And then, one final message. Accounts describe a note left for Justice Harlan, taunting the Supreme Court and mocking its authority. The wording varies depending on the source, but the intent was clear. They wanted the court to know. They believed they had won. The next day, Chattanooga's black community responded in one of the only ways it safely could. Many stayed home from work, effectively a strike. City officials panicked over unrest. The mayor closed saloons and deputized hundreds of men. Historical summaries report that about 2,000 mourners attended Johnson's funeral in the days that followed. Nationally, the story spread fast, not only because of the killing, but because it looked like a constitutional crisis. A mob had effectively told the Supreme Court, "Your orders don't matter here." In Washington, powerful people took it personally. President Theodore Roosevelt condemned the lynching and pushed for investigation. Attorney General William H. Moody directed federal attention to the case, because this wasn't only murder, it was an attack on the rule of law. And here's the twist, the part that still feels unreal. The Supreme Court decided it could not let this go. It initiated contempt proceedings, United States v. Shipp, charging Sheriff Shipp and others with contempt for failing to uphold the stay and protect Johnson. It remains the only criminal trial ever conducted by the U.S. Supreme Court. Think about that. The Supreme Court doesn't normally do this. But the court treated Johnson's lynching as an attack on its authority and on the law itself. While around 24 men were initially charged, the case narrowed. Convictions came in May 1909. Sentences were imposed in November 1909. Short terms, like 60 to 90 days, depending on the defendant. The court concluded Shipp had effectively made the mob's job easier. And yet, those sentences, measured in days, sat beside the reality that Ed Johnson's life had been stolen. And Johnson's attorneys paid a price too. Historical accounts describe threats and retaliation that forced Pardon and Hutchins to flee for safety. So yes, there was accountability, but it was narrow. And for decades, Johnson remained guilty on paper. Justice didn't come in months or years. It came almost a century later. On February 25, 2000, Hamilton County criminal judge Doug Meyer set aside Ed Johnson's conviction and vacated the death sentence, acknowledging the unfairness of the trial process that led to the verdict. The court couldn't bring him back, but it could remove the legal stain pinned to his name. And in the years after, Chattanooga began slowly, imperfectly, to reckon with what happened. In September 2021, a memorial was dedicated near the bridge site, and city leaders publicly acknowledged the injustice. Ed Johnson's story isn't just about a wrongful conviction. It's about what happens when guilt is decided in advance, and the system, through fear, bias, or convenience, doesn't stop it. It's about how quickly due process becomes optional for the people society values least. And it's about how the law can still matter, even late, even imperfectly, because it creates a record that future generations can either bury or finally face. So here's the question I want to leave you with. If justice can be delayed for nearly a century, what does it take to make sure it isn't denied in the first place? Because sometimes the most haunting crimes aren't hidden in the dark. They happen in the open, and the world learns to live with them. A bridge can carry people forward unless we refuse to look down.